All right, let us do this. It's getting kind of exciting, I have to say. We've got, we got, we had some things go down here. We went and the deliberate indifference crew, we could say, descended on Madison for a hearing here in the Stoller case versus the Department of Corrections, and they were sitting there ready for us. They sure were. They had the police. We were in the hearing room. Armed police officer from the Capitol Police was in the hearing room, sitting behind me as an opening move. The respondent, the Department of Corrections, in my opinion, was pretending like they had no knowledge of what was going on. But it's clear to say the last communication that I had with the administrative law judge on this issue was that the public, meaning Deliberate Indifference Wisconsin, was going to be there and very likely going to record the proceedings. So I have no doubt in my mind that that was the original purpose of having the police there, was to potentially eject Debbie Keith or whoever might appear to record the hearing, the public hearing. There was we spent at least an hour discussing whether or not it was a public hearing. Now, I just, left the room because it wasn't any part of me, but the judge seemed to be, I would say, obsessed with the concept of whether or not it was a public hearing, which to me seemed outrageous. Just even the mere thought of it. I mean, is this a courtroom or is it not a courtroom? When is it a administrative hearing? When they don't want YouTube there? When is it a tribunal of the law? When they want their way and to apply the law their way. So that was the first mention of YouTube that day. The next thing was we talked to Officer Pomeroy pretty early on, I would say. He asked us to tone down our rhetoric, our argument. I don't know why he had any part in doing that or was invited there or whatever. We didn't find all that out till much later, of course, but, we got it all on recording. I made an argument because we found out on cross-examination that the Department of Corrections attorneys had asserted that Kevin Carr, the secretary, didn't know anything, right? We had a whole video on that. So I made this argument to them, and they didn't consent to me saying that out loud, which is what they did. They called the police, and within 3 minutes or so, the police were there in my face asking me questions on the call from the state's Department of Corrections. Andrew Olmanson called the police during the hearing, and the judge didn't do anything. The administrative law judge, the hearing examiner, Benitez Larissa Morgan, said nothing. She gave a statement to the police and went out and said she had nothing to do with anything. I think the Madison police were at least smart enough to understand that it wouldn't be a good look to try to issue a citation for disorderly conduct for an attorney who's advocating on behalf of his client. Time number 2, they mentioned YouTube. These police. They couldn't remember where they had heard it, but they knew I had a YouTube channel. And they asked me to tone it down. That's what they did. They sure did. So that was, it's not a way to conduct a hearing here. Me sort of shaking, having to, in fear of being arrested, and the opposing counsel sitting there smiling with her friends at the state of Wisconsin behind her. It really was a disgusting welcome. I can say that for sure. People like Matt White, who we've talked about on this channel, popping in and out, hiding, I would say, for lack of a better word, sort of running away in the other direction when he sees me. I sent him an invitation, let's do lunch. He couldn't bother to respond. It was that level there, but mostly and in particular, the police said that they were there for everybody. The judge said that they were there for everybody. The police were there just for everybody. It wasn't for me. It wasn't for Debbie. It wasn't for the respondent. It was just, in general. And the judge at least was clear that she was the one who invited the police from the get-go. So at least they got that story straight. I think we have had, I don't know if I discussed this before, but we had another issue there on that Wednesday night, the night before Rosh Hashanah. The opposing counsel wanted to leave early. No question. Fine. Perfectly legitimate. No problem about it. But we stayed till 7 o'clock the night before, but for some reason the next night there was a problem. The judge said that she was told, but she refused to tell us who told her that we had to leave early. And then she first said it was the police. So then I went and asked the police. The police said they didn't tell her. She wouldn't again tell us because she said it was because of my bad attitude, that she wouldn't tell the parties who it was told her that we had to leave the hearing. The hearing had to end at 4:30, which then got changed to 5. I have a video of the judge telling the police that we have to end at 5 because of the religious preferences of the respondent. Which then I also have a video of the judge saying that that's not the case at all. I have a video of the police telling me that the judge is the one that told them. And again, it's kind of nice because I have the video of the judge. The judge, by the way, whispers to the police when she tells them that we have to leave at 5 o'clock because of the religious views of the respondent's attorney. And just to be clear for the record, the respondent's attorney said that she wanted to leave at 6. So that was kind of hogwashy from what I could tell. And I think we're like halfway through there. We managed to conduct 2 days of hearings in another office. The first one was just tiny. All that while there was a police, more or less continuous police presence in that room. Sometimes they would come, sometimes they would go. At 4 o'clock, there was always a police officer who came, and then they would get really insistent upon us leaving the building. That was kind of interesting. Of course, we've got videos on all this, which we'll get out there. You know what? If I just gave you the raw content and didn't talk about it, where would I be? So, thing number 2. If you all haven't noticed, I have held back a lot of things, but there is so much content that is waiting to come out on the Department of Workforce Development, and I think they've got a few things to answer for. This use of state violence to chill free speech was kind of the last straw as far as I am concerned here. Them threatening me, constantly accusing me of being disorderly. I mean, it was the thing is here's how it goes. Even if the Department of Workforce Development and the Department of Corrections attorneys didn't, get together ahead of time, didn't matter, because the judge uses police power to scare YouTube away, emboldens the Department of Corrections to claim that there's disorderly conduct and that they don't consent to me saying on behalf of my client that they need to correct their false statements. And let's be clear, we've got, of course, the recording of that too. But nothing other than that was enough for them to call the police. And for the police to continue to treat yours truly as if I'm a threat. That was also astonishing, because the only threat was YouTube. Is YouTube. And I think when these videos come out, there'll be something, people may have opinions on the conduct of the police. They may have opinions on the conduct of Andrea Olmanson. They may have opinions on the conduct of the judge that the judge and Andrea Olmanson and the police were trying to prevent. Seriously, you'll see in one of these videos, the cop says I heard that you had a YouTube channel. So I immediately asked him, where did you hear that? He said, I think he said something like, I heard on the way here that you have a YouTube channel. I asked him, then he tells me, gaslights me 3 times, tells me something like, I hear so many things in the day. And then finally he gets down to say, I just don't remember, which is just like, obviously, dude, Officer Pomeroy, why say, I mean, seriously, why do that? Why not just, because you will hear this concept with the police, which is called a furtive glance or furtive action, or you're acting suspicious. Why just tell the truth? Why lie, police officer, to me about why you're there? Why lie to me about, the fact that you know about the YouTube channel? Why lie about the fact that just say, I'm here to suppress your free speech? It's just more honest that way. You know, the Wisconsin nice, we're going to see all that, does not cover up the violations of the First Amendment. Why do it? Why not just say, I'm here, I have a gun, and I'm here to intimidate you and to keep you from showing the citizens of the state of Wisconsin how the government of the state of Wisconsin acts? Why not just say that? I don't know. You know, that's, I think, the inherent contradiction in Wisconsin nice is that it's a big fat lie. So then we get to Mr. Rusty Lang here. He's the head doorman. And I don't mean to say that as that his work is not noble or whatever, but that was until I learned that he was the section chief of the administrative division of the Bureau, the Administrative Services Bureau, or I hope I got that right. He was just Rusty to me. Of course, he had interactions with Debbie Keither and, so forth before that, but he was just Rusty. I didn't know it was Rusty with an IE, or Rusty Lang for that matter. Didn't know it. No problem. So we go there on the last day, and we're back in this tiny room. And I say, look, this tiny room is not going to work out with your police officer breathing on me and right across from these people who are telling me to tone down my voice and so forth. Andrew Olmsted would do this if she didn't like my volume. I really have never experienced a hearing like the one that I did. The bottom line is that the complainant, the person who was sexually assaulted, who claims that she was sexually assaulted, was prevented from putting on her case. Bottom line. Intimidated, prevented, and putting on your case is an act of free speech. Let's be clear about that in and of itself. And her free speech rights were fundamentally denied and trampled all over by the Department of Workforce Development, the Department of Administration. They control the police there. Same with the Department of Justice, somehow involved in all this. And of course, the Department of Corrections. So one hearing, and normally with these workforce development ones, you're used to seeing me fight the government respondent, the employer, and the judge here. But now we had the judge, the police, and these secret agencies behind the scenes. So I have this conversation with Rusty Lang, and we'll get in. We got the recording. It's unbelievable. So we are talking about why can't we have a bigger room, and he's just seriously, every one of them is just gaslight, 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 gaslight. Why not just say, Ben, there's a panic button in the room? But no, we had to dance around. There is special equipment that this room is the only one that's equipped, and that's the facts. And why aren't you listening to the facts when I tell you the facts? So, he got frustrated because I kept calling out his gaslighting, and I think he blew the gaff. So I think screwed the pooch is another one. He said some things they shouldn't have said, or he said the truth. But either way you look at it. So he told me that the police were not there for anybody else, but they were there because of me. Okay. Now, problem about that is that they were there before I got there. It's only a little problem with that, but okay, fine. No problem. There's a video of me walking in there. I'm out of breath, sweating. It's because I've been carrying around video equipment for some time. Well, we didn't know where the place was. Fine. Now, Rusty makes another interesting comment. He didn't like something that I had said. Fair enough. Many people don't. And his point was that I shouldn't have said it because I'm a plaintiff's attorney. Might have been a good point, might have been a bad point. I don't know. I asked him point blank, do you know what this case is about? You know, it might have been relevant to what, if anything, that I had said. Might have been. Who knows? Might have been. Maybe if you understood the context, you would be thinking that something completely different. Or who knows? It's up to you. Up to him. Doesn't matter. What matters here is that his response, this is the government actor, the state actor, here's response, says, I don't need to know the facts of the case. All I need to know is that you're on YouTube. This is after telling me to grow up and telling me, that he basically threatened me as an attorney. I thought he was trying to fight me. He says he's going to call me take me to the carpet, I think. He asked me to come outside with him and the police officer. If you can understand that some other way than trying to threaten to fight me in front of the police. It was astonishing conduct. That is, for sure, my point of view. We got all that on recording. Then I go and walk around the building because what the heck? I go put some change in my car. I come back and this police officer is in my face, telling me that I have admitted to roaming around the building and that I can only go certain areas, like basically there to down one hallway. And he shows me that there's signs, which he claims that they have been there before, gaslighting more. The sign, if it existed, was pointed the other way. And they put up signs for me, because I assume they don't want everybody to know that this building is 80% vacant. It's the whole issue is they kept gaslighting me about we don't have any meeting rooms are available. And of course, there's a whole building full of empty meeting rooms because all of the government workers are working at home. I mean, literally, nobody is there. The secretary's office, we got picture after, it's unbelievable. So he threatens me. This police officer threatens me and cites an administrative code saying that, alleging that I went into somebody's office or an unauthorized area. And I'm like, dude, show me where something says that any area that I went into was unauthorized, please. And so they ex post facto put up this hilarious sign just for you, truly. And it was at that point that I realized what was going on here, that I was getting the Debbie Keither treatment from, not from MPS this time, but MPS is usually the one who gives the Debbie Keither. This is, violence, the gaslighting, putting up, making special rules just for you. Police didn't tell the respondents where they could go. Police didn't escort the respondents around the building. I literally had to get a police escort to get my water bottle filled up. Because that's how you conduct a hearing in a non-prejudicial light for your complainant. That's how we in America advocate for our clients, is with a police escort. That's what happened in Madison, Wisconsin this last week, the first week of October 2024, really under the nose of the governor. I cannot tell you, I've heard this, I'm following this cop around. He's on the phone. He's listing off the whole alphabet of the universe. Everybody, it's seemingly at the Capitol, knew what was going on in my hearing except for me. And certainly not the complainant whose day in court it was. But I think if anything that this channel shows is how the DWD doesn't really exist for the complainants to have their day in court. It exists for bureaucrats to have a job. And I think that's fundamentally what the problem is that they're, again, more concerned. Yeah. You know, I just learned on that subject today that they threw a fit because I supposedly videotaped John Gelhard without his knowledge, and they, was that unethical? They threw a whole thing on that when they tried to come after me for my ethics. But when you look at the video, it's very clear that I'm telling him point blank that I'm recording it. It's the play like of violence, threats of violence, actual violence, gaslighting, changing the rules and special rules just for you, that I guess puts me in that honored class of being a Debbie Keither. So, in some ways I can thank them for this experience. I certainly have grown and learned here. But under Tony, I won't quite say North Korea. It's like, lower level province, China, 10, 15 years ago, I guess, is not under currently. It's kind of the rate of repression is what I'm feeling here. It's astonishing. It's certainly not the reputation that Wisconsin or Madison would like to uphold, but that's the face of the reality that we have to deal with because it's true. So let's close this out with the kicker, shall we? It's kind of fun. Wish I had a little sound for that, but I don't. So we are in our final moments of the hearing. Now, remember, we already revealed what we knew, what the previous judge had denied, which is that Kevin Carr was the decision maker. Now, the way that it goes is there's something called a MAT team at the Department of Corrections. Why you care, just hold on with me for a second. They make a disciplinary recommendation to the secretary, who then makes the ultimate decision. Now, Judge Gelhard, the previous judge, decided that the MAT team and not Kevin Carr makes the decision. And he literally wrote that Kevin Carr functions as a rubber stamp for this MAT team. Where he got that idea? Oh, it was from the attorneys, in my point of view. And the attorneys then, especially Andrea Olmanson, then came and advocated this position and said, as Judge Gelhard educated you, it's really the MAT team that makes the decision, not Kevin Carr. We had that rubber stamp one. Okay. Well, how could this get worse? Any ideas? Any ideas how this could get worse, especially for the DOC? Well, it turns out simply this. We asked Kelly Brown, Kelli Brown. I think it's 76 in the Novak series, but don't quote me on that one. She is the subordinate of Carrie Beyer. Okay? What does she say? Well, so for some reason, we're talking with Carrie Beyer about the MAT team, and there's an attorney, there's legal counsel that's in that meeting. Well, the question there was who outranks who. Carrie Beyer said that she outranked the attorney. Oh, that's pretty interesting. Okay. Didn't occur to me at the time to ask for the name of the attorney. I only occurred to me to ask for the name of the attorney under Kelly Brown. It was just for the record. Just for the record. Fierce objection. And of course, I already gave it away. And guess who the attorney that sat on the MAT committee and participated in the discussion, the decision making the whole time was? Of course it was Andrea Olmanson. Of course it was. It's the same Andrea Olmanson who signed the interrogatories, who refused to tell us how the decision was made because she said it was attorney-client privilege. And then what happened? The judge asked the witness some very leading questions, in my opinion, to try to get a response from her that it was okay what Andrea was doing. She wasn't a witness. She wasn't a part of the decision-making here. She was actually still an advocate. So, I objected to that, but more importantly, I got the opportunity to ask a few more questions, and it came out point blank from Kelly Brown that, of course, it's a collaborative process. We're all working together here. We're all participating in the decision making, as opposed to giving advice. And then, lo and behold, the attorneys immediately started arguing that, in fact, it was Kevin Carr and not the Matt team that made the decisions in this case. And that's exactly what the problem is here. Exactly what the problem is here. It turns out that Andrea Olmanson has been vociferously defending her own decision. That's why we had to drop the case. That's why I was insane. That's why I was supposedly using drugs. That's why, my career was going to be at an end. That's why my family, there's going to be consequences for me and my family and my law firm. That's why. Because she was the one who participated in the decision, and her decision had to be upheld and couldn't be questioned. Had to be something. I will admit freely that I did not see that coming. And I guess womp womp from me. But we got it. So that's the story. Thanks for sticking with us on this one, but that is the story. Andrea Olmanson was up to her ears in all the facts of this case from the beginning. And she participated in the decision-making directly in this case. And then on the question of whether or not she was a witness, she told the judge that she just was taking in information, but not as an actual witness. She was just taking in information. And I think it was fundamentally dishonest any way you look at it for her to say that you should follow what the judge said, that let the judge educate you that it's the MAT team and not Kevin Carr Management Advisory Team. That's what MAT team stands for, M-A-T. Not Kevin Carr that's making the decisions here. And not to tell us that she's the one who's always at that meeting, who's always participating, not necessarily as giving legal advice, but to be there to give a legal perspective. And that's the problem, is that the evidence here is that she participated in the decision making. Nobody said any advice. Didn't happen. We asked her straight up, is there any time when the attorneys left the room so that you all could make the decision? No, the attorney's always there. Oh, okay. Okay. But you can't have it both ways and shield it from attorney-client privilege, have her be the attorney, and then also have her participate in the decision. Believe me, I've been through that one enough times to know that when the attorney is ultimately a part of the decision maker, as opposed to an advisor, that's the line. And it's my opinion that it was absolutely disingenuous for Andrea Olmanson not to have revealed that fact the numerous times I believe that issue came up. And certainly not when asked straight out in discovery and to say, no, that's attorney-client privilege. I don't think that's acceptable. But it's not my decision to make. Those are just my feelings. So, all right. Thanks for sticking with us. We'll keep you informed. I got some editing to do. We'll get to it. The combination of audio plus video is something that gives my mind a bit of a whirl. But I'm sure it'll be worth it. Cool. All right. So obviously I just reset my sound machine and you've got some funny sounds here. If you didn't get the theme here, let's at least close with the theme. My goodness gracious. I mean, where would we be without the music? Seriously, thanks for it was been a tough week, and many of your comments throughout this week really helped me get through it, and I appreciate that. So thanks for sticking with us. We'll keep you informed.